Calling case number 8-831-379, Nikolai Shaparov versus Infinity Lifestyle.
And state your appearances.
Good afternoon, Your Honor, and happy New Year. Teddy Parker, Eric Pepperman, and Breanna Switzler on behalf of Plaintiffs.
And Tyler Watson, Mike Esposito, Gina Mushmeche, and Brad Johnson for the real water defendants.
And Sebastian Capardo.
Eric Freeman also for Real Water. Apologize, I couldn't be there today in court.
That's okay.
Good afternoon, Your Honor, Jim Cavanaugh and Nate Arrington and Dan Polsenberg here on behalf of ETT1 DBA Terrible Herbst.
Okay, is that everybody? All right.
Good afternoon, Your
So
Honor.
go ahead.
Sorry, on Zoom, Colt Dodrill, counsel for Nevada Beverage.
Okay, good afternoon. So we have 25. 20? Okay. So I think we have 20 on for today. Is that everybody else's kind of rough understanding at least?
That's the number we have, Your Honor.
Okay. So that means today and the other day, we do have a limited amount of time. So, given the number, rather than say, oh, you have, I don't know, 5-10 minutes per, I'll leave it to you all to figure out how much time you want to spend on any particular argument. But I do have to limit your time because we don't have an unlimited amount of time. It's about 1:50 now. We'll go to about 5. We'll probably need a break, 3 something. So you've got basically an hour and 15 minutes total. Plaintiff, defendants. So just be aware of that. I'll leave it to you to, figure out. If you want to take 1 minute on the motion, that's fine. If you want to take 5, 10, 15, an hour, that's fine by me too, but we do need to get through these. So we'll be timing you. Any questions about time?
Not from Plaintiffs, Your Honor.
No, Your Honor.
Okay. So which one are we starting with?
Oh, I thought you were referring to your law clerk, Your Honor. I
Oh,
apologize. I believe
is
it's
there
starting,
a-
Your Honor, with plaintiff's motion limiting number 1.
Okay.
That's my belief.
Okay. And I built, to be clear, I forgot to mention this, I did build some time in for my speaking into that, so you all know. So I'll tell you what I'm inclined to do, generally. So on plaintiff's motion limiting number 1, inclined to deny this one, because I think the issues go to weight of the opinions, subject to cross-examination, etc. I'm inclined to deny place motion limiting number 1, but welcome arguments.
Your Honor, is it okay if you gave us your inclinations on all of them? That may help in terms of how we decide how much time to use.
Okay.
And all the defendants have a position on it. But I think it makes some sense
Okay.
in terms of efficiency.
So next up, according to the list we got, would be plaintiff's motion for summary judgment as to 1, plaintiff's claims for strict product liability and causation gets Nevada Beverage and ETT1 and 2.
Your Honor, you appreciate the fact that we're done with Nevada Beverage. We've reached.
Yes.
Okay, good.
But a lot of these have joinders, I think.
It does. I just wanted to make sure the court was.
Okay.
Thank you.
Yeah. So plaintiff's motion for summary judgment is 1, plaintiff's claims for strict product liability and causation against, I guess now, Terrible Herbst. 2, that defendants sold, and I'll have a hard time saying this one, sold an adulterated product be inclined to grant part, deny in part, grant in part as to number 2 there, deny in part as to number 1. Plaintiff's motion for summary judgment as to 1, plaintiff's claims for strict product liability and causation against Real Water, and Real Water defense sold an adulterated product. I mean, given what I just said, probably grant is number 2. This one we might need to talk about, because I got an opposition filed on December 29th, I think it was.
That is correct, Your Honor. We haven't had a chance to do a reply, and of course, we filed a notice of non-opposition.
Um,
And Your Honor, if I may, there's an ex parte request for an October relief on that.
oh, I know there's that too, but that's why I'm saying, so you all think about this, I guess.
Thank you, Your Honor.
I'm trying to think of how to say this. Do plaintiffs want an opportunity to submit a reply, or do they want to go forward? No, so think about that, I guess, would be, and what, if anything, I should do on that one.
Thank you, Your Honor.
Joint defense motion for summary judgment against Herbst plaintiffs on issue causation, inclined to deny without prejudice because genuine issues of material fact exist. Plaintiff's motion for summary judgment that all medical expenses related to the consumption of real water were reasonable, necessary, and customary. So this, and it's probably part of the sheer amount of volume on these, but this one in particular, according to my notes, and I did even re-review these today even, but some of these were confusing in terms of who potentially is subject first versus all plaintiffs and vice versa. So that was a question I had on this one, but I'd probably be inclined, I went back and forth, quite honestly. I ended up being inclined to deny it's premature because the causation remains an issue. But like I said, I went back and forth on that one some.
Does that mean we just have argument on that one, Your Honor?
Oh, you could have as much argument, as little argument as you want on any one of these. Plaintiff's motion limiting number 2, pre-admit governmental reports, inclined to grant. Defendant's arguments or go to weight of the evidence, not to admissibility. Plaintiff's motion limiting 3, pre-admit FDA concentrate testing reports, same thing, inclined to grant for that same reason. Plaintiff's motion limiting number 3, pre-admit FDA concentrate testing reports, inclined to grant for the same reasons. Plaintiff's motion limiting number 47, I guess.
Yeah.
Okay. This one was a little different, I think, than the other ones. So I welcome arguments on it, but I'm not sure foundation is there to pre-admit. There are different issues with this than those other ones I just talked about, so I'm probably inclined to deny that one. Plaintiff's motion limiting number 6, preclude real water toxicologists, apologies to this person, stealth lug from offering opinion that there was insufficient hydrazine. Probably inclined to deny, but I have deny with a question mark, so that means I certainly welcome arguments. Place motion, leave number 8, pre-admit real water epidemiologist, Dr. Goldsmith, inclined to grant that one. Plaintiff 9, inclined to grant, on particularly as the lack of qualifications. I think the opposition essentially ignores that issue. This one was interesting, that plaintiff's motion limit number 10, on the Superfund sites, municipal water being possible causes. I'm inclined to grant, questions are, how are these quote unquote opinions relevant? How are they not complete speculation? How would they not lead to utter confusion? And there's some serious issues with that one, so I'd be inclined to grant. Plaintiff's motion limit number 7, preclude Donnelly from offering expert opinions fairly to list the items, inclined to deny that. I think same on number 8, number 36, Catherine Donnelly, failure to list, inclined to deny. Plaintiff's 11, pre-instruct the jury, inclined to grant in some form. Although the devil's certainly in the details, and I may tell you to meet and confer, but I think pre-instructing is a good thing in a case like this. The question is, the details of that. So I might make you meet and confer, try and figure out more details and continue the hearing to some other time. 20 motion limit 25, prevent Donnelly's from speculating, inclined to grant that one in particular for the reasons detailed in the reply. I think that's the one where the case that defendants talk about doesn't quite say what they think it says, I think. But I could be getting that confused because there's a lot of motion. Plaintiff's motion limit 12, designate Blaine Jones managing speaking agent of real water, be inclined to grant part, deny part, do the exact same thing that I did in the Wren case. I don't think any issues have changed, and I still think I'm right for what I did before. Plaintiff's motion limit number 18, preclude reference to the fact Blaine Jones now plaintiff. I'd be inclined to grant that one. Plaintiff's motion allow juror notebooks, pre-admit plaintiff's exhibits related thereto. I'd certainly be inclined to at least, this my note, at least grant part specifics, though, question mark. Yeah, I think a plaintiff notebooks are appropriate, and then we need to talk about details and specifics. I was gonna say, I know those aren't all of them. Oh, that's all of them. Okay. Wow. Okay.
Can we have a quick second to see if we can reach a report on which one elected you want to argue? I think you've saved us a lot of time already.
Okay.
I don't know who would be arguing from each side, but.
If you all want to take 5 minutes, that's fine by me. Let's go off the record.
On the record, Judge.
Okay. Any updates?
Your Honor, I think we've been able to remove at least about 7 of them that we're not gonna argue.
Okay,
There's some that we're gonna make statements more akin to seeking clarification. We'll see how
okay.
that turns out. But we will reach some agreements, you know, I think you saved us a significant amount of time. And we appreciate you giving us your thoughts in advance.
Okay,
The first one we would like to argue from the plaintiff standpoint, Your Honor, is the number one on the list for today. This involves Atchison, Dr. Atchison and Dr. Tenner. And I know the court, and I appreciate the court's inclination is to deny, believing it goes to weight as opposed to admissibility. I think that's my understanding, Your Honor. We believe this came down to foundation as opposed to weight, and we were looking at foundation based upon, of course, the Hallmark case, Marsicato case, the Williams versus the Judicial District Court case. We believe that based upon those cases, these two experts who are not, as the court probably recognizes, are not hepatologists, don't have the appropriate foundation to provide opinions. Additionally, through the deposition process, Your Honor, we were able to solicit testimony from, for example, Dr. Atchison, admitting that he is not an expert when it comes to cirrhosis of the liver caused by alcohol. And so while I would love the opportunity to simply have that go before a jury, Your Honor, as the gatekeeper under the case law just mentioned, he doesn't get to the jury. He doesn't get to the stand. It's our belief, given his deposition testimony, because he's an epidemiologist, Your Honor. This is the one who is trying to, as an epidemiologist, assert a case-specific opinion, which epidemiology does not really work for that. Typically, that's a doctor, not an epidemiologist, and who would provide a case-specific causation opinion. And so, Your Honor, looking at the deposition sites we've referred to, he also, in addition to saying he's not an expert when it comes to cirrhosis of the liver caused by alcohol, this is something that I believe would result in jury nullification, because he says in his deposition, there was exposure to 5-gallon bottles of real water to some agent that caused acute liver. I'm not convinced it was hydrazine that caused it, but there was something in there that caused it. Your Honor, this is page 39, line 16 through 24. The court's already decided, based upon the hearing on December 3rd, that these products were defective, that these products contained hydrazine, and based upon the exact order from Judge Kishner, that's the cause of the liver injuries that were suffered. Your Honor, he can't give that opinion and not run afoul of the court's already decided motion for summary judgment. And if you like, Your Honor, I can put it on the screen and show it to you. But that's the foundation. His foundation is that there's no evidence, and he's not convinced that the acute liver failures had anything to do with hydrazine, and that real water was the cause of it. So he can't give an opinion and not run afoul of the court's decision. And he further said on page 40, and I just believe epidemiologically that the 5-gallon jugs caused the outbreak of acute liver failure. Well, Your Honor, the determination's already been made based upon the facts in this case and the evidence that you've seen yourself, that the real water jugs and the real water retail bottles were made from the same concentrate with the same process. And he says, this is page 105 of his deposition. And again, as you remember, Your Honor, before you issued your order on December 3rd of this year, Judge Kishner in 2024 found in favor of plaintiffs and against Terribles on the exact motion for summary judgment. And despite that, this is what this expert says. I still believe that retail real water was not a problem based on all the facts that we've discussed today and on prior depositions, knowing that, Your Honor, he's been excluded as an expert 3 times in the prior cases. Now, I will say real water chose to bring hepatology experts. Terribles brought an epidemiologist. to try to give a case-specific causation. So I understand because of the way the opposition was phrased, Your Honor, where the court's inclination was, because when you look at the opposition, they reframe the issue. They don't focus on the foundation. And so when I looked at it, Your Honor, preparing for today, and I've had a lot of time to look at it, of course. If you take just the opposition, I see exactly where the court's going, because they've reframed the issue. But when you look at the foundation of Dr. Atchison, he simply does not meet the requirements of Hallmark, Morsicato, and Williams. And he says, I do believe that there was a problem with the 5-gallon jugs. And if there was evidence to say that the same problem in the 5-gallon jugs was in the retail water to the same level, then I'd be telling everybody in the world not to consume real water. Again, he's going against what the decision of this court has been, the decision in every case that we've had where Terrible has been an issue. And that's why he's been struck by the previous times, because he has not been able to provide the foundation for a case-specific opinion, Your Honor. And in this case, it's no different. And so and I know that this has been a year ago, over a year now since the last court trial, Your Honor, in this case for you. But certainly you recall all of the testing done by the FDA, Eurofins, all proved that they all had hydrazine. So there is no difference between the two. And because his foundation is based upon that there was no hydrazine, that there was some difference, he lacks foundation to give the opinion on. In addition to, of course, being an epidemiologist and not a hepatologist. And then, Your Honor, in terms of Dr. Tenner, again, he's not a hepatologist. He's a gastroenterologist. And Your Honor, you know the difference having been through this case. A gastroenterologist generally will provide information on the digestive tract, whereas a hepatologist focuses on the liver. Hepatologists are the ones that typically treat DILI. And that probably rings a bell with the court. DILI being a drug-induced liver injury. That's what we have here in terms of experts giving specific causation opinions. In fact, Real Water experts Cohen and Sato provide hepatology opinions, whereas Tenner is not a hepatologist. He also says in his deposition, I don't know what the real water concentrations of hydrazine are. And again, that's also speculative. Fine. Then he adds to that, I think if I remember those 2020 cases, I believe that the hydrazine was not the etiology, saying that the hydrazine was not the cause. Your Honor has already made that decision. 2016, 18, 19, 2020, you've had cases with all those years involved. We've had cases through the 5 trials spanning all those years. And yet he gives an opinion which is contradicts the court's finding already in this case. I feel, I'll continue, Your Honor, page 26 of his deposition. I feel strongly based on prior outbreaks of hepatitis that it was more likely an unknown virus. This is page 26, line 20. Your Honor, you've held this before. An expert can't come to the stand and talk about unknowns. They can't speculate to what might have caused. And based upon, of course, Williams, if you're going to say it's something else, you have to do it to a reasonable degree of medical probability. Dr. Tenner does not do that. In fact, he says he's speculating. And we pointed that out in our briefing, Your Honor. He says here, he claims this circular argument that Milo Herbst suffered from cirrhosis caused by alcohol, and that because he was drinking, that's the cause of it. So the result serves to be his predicate. So he was asked during his deposition, and he says, I'm speculating because we have not idea. I'm reading it verbatim, Your Honor. I know it sounds strange. We have not idea what the mechanism is, why 1 in 10 people who drink alcohol moderate to heavy over their lifetime development of cirrhosis. Question then, you're speculating he is 1 of the 10% because he got cirrhosis, correct? Correct. He's speculating as to whether or not Milo Herbst's cirrhosis was caused by alcohol. He didn't consider whether or not it was caused by hydrazine and real water. And as the court remembers from Williams, if you're going to give an alternative causation opinion, you have to do it to a reasonable degree of medical probability. And you must at least consider the plaintiff's causation opinion. And this is what he says in terms of considering that other causation opinion, page 88. And you disagree that retail bottles of real water can potentially cause acute liver injury, correct? This is his response. I found no evidence that the retail bottles cause liver injury. Again, going against what this court has already decided. The retail bottles are no different than the 5-gallon jugs. Same concentrate, same process of manufacturing, same facility, Your Honor. That's his opinion, Your Honor. So I'll wait for some rebuttal, but I wanted to make sure for the purposes of the record that I understand what the court was saying in terms of weight versus admissibility. And I would agree if it was not if it wasn't framed the way it was in the opposition, because which I give them credit for this, they took this distraction attempt, took the court's view away from foundation. And I wanted to make sure we put the foundation at issue, Your Honor.
Thank you.
Thank you, Your Honor.
Afternoon again, Your Honor. Jim Cavanaugh for ETT1 DBA Terrible Herbst. Put simply, I believe what counsel is mistakenly doing here in his argument is conflating causation with adulterated water, built on or not. Neither of these experts were arguing adulterated water and or its effects on the human liver. For instance, both of these experts are qualified in medical fields as well as epidemiology. And taking Dr. David Atkinson's opinions, he initially is looking at the outbreak, and he's looking at what until recently was the prime claim of all the plaintiffs, an acute non-viral liver injury. Cirrhosis is not an acute non-viral liver injury. In cirrhosis, it's a chronic condition. And what both of these experts, who are eminently qualified and able to, because of their study of the records, including the plaintiff's medical records, and within their areas of expertise, epidemiology and gastroenterology, are able to say, based on the abundance of records that really can't be disputed, that Mr. Herbst had a history of alcohol consumption. He had a history of medical records dating back to 2016 that we know about that demonstrated he had alcohol-induced cirrhosis of the liver. And these experts' opinions about what caused, more likely than not, Mr. Herbst's condition was not a speculation. It was based on the records, and it was based on their particular fields of expertise. Again, Atkinson looked at the outbreak issues. They're totally different than what happened with Mr. Herbst. And underlying all of this is the causation issue. You can't get away as a practical matter from the causation issue underlying their opinions, because it's at issue now, even as we've gone over the pretrial motions. Your inclination, Your Honor, I believe is correct, because it does go to the weight. These are qualified, their opinions are assisting a juror to understand this, and they're testifying within their areas. Dr. Scott Tinner has been a liver disease treating gastroenterologist for 25 years. It's a Harvard educated Brigham and Women's Medical Facility director and well acquainted with liver diseases, which he's had clinical experience all his life treating that. And it's a well-known fact. It's not speculation that alcohol creates a lot of problems, and it's not just for livers, but it does and did, in their professional opinion, to a reasonable degree of medical probability, underlie the cause of Mr. Herbst's injuries.
So both of them opine as to what Mr. Park called case specific causation in terms of, and this is a lead up to a question, so I apologize if it's not coming across as such, but I am trying to formulate the question. So both of them opine that case specific causation vis-a-vis Mr. Herbst was his cirrhosis caused by alcohol consumption. Is that a fair summary?
I think it's their medical opinion, and their opinion as epidemiologists is more likely than not the actual cause of a chronic cirrhosis of the liver condition. I'm not sure it was case specific, and it's, remember, both of these were also rebuttal experts. And the standard for their opinions as a rebuttal expert is somewhat different as well. Again, I think what's being conflated here isn't some argument that seeks to backtrack on this court or any court's prior findings on the content of or the hydrazine issue. And this is about causation. And it's about, within their medical specialty, looking at the facts, looking at the outbreak issues that underlie the first lawsuits that the courts have tried. And this is a different plaintiff. And it also goes to this idea that the speculation here, the speculation is that real water may have specifically caused his injury. There's at least 20 doctors that have medical records going back to 2016. They're not speculating. This gentleman has cirrhosis of the liver, and it's related to his self-reported alcohol use over a period of about a decade that they knew about. The speculation is not on the part of these defense experts. And I view this as a general opinion that goes to help the jury understand what may or may not be the cause of this plaintiff, Milo Herbst, injuries and death. And it goes to the weight, Your Honor. There's just no good reason to disqualify them on the Milo Herbst case. And their opinions are well stated. You can cherry pick parts of a transcript where somebody asks a hypothetical question that is based on a hypothetical, and cherry pick an answer where somebody says, well, you're right. We don't know for sure why this particular patient would be one of the people that is less affected or more affected by the use of alcohol. But when you add them up and look at the outbreak and what's occurred with the real water cases, it's more probable than not that this particular patient, this particular plaintiff, is injured due to use of alcohol over a prolonged period of time. And there's just no evidence otherwise with regard to real water.
So on that theory, isn't there, I mean, and I don't know that this necessarily goes to this particular motion, but isn't there an issue with that type of theory in terms of, in law school, we learn about the eggshell plaintiff.
Mm-hmm.
I mean, if I'm having a hard time overall understanding part of defendant's argument with Mr. Herbst, because it seems to overlook the eggshell plaintiff rule, that, regardless of whether he drank how much ever amounts of alcohol, and plaintiff talks about Nevada law and substantial factor, I'm trying to ask a question, I'm doing very poorly at that. I- Yeah, I can't even formulate the question, apologize.
May I say, Your Honor, the eggshell plaintiff is an issue here. I understand the court's mentioning that, but it's a chicken and egg situation as well. And in this particular case, we have minimal to zero in the defense viewpoint of anything done by the defendants that would have harmed the eggshell of that is Mr. Herbst. And so it's chicken and egg. We do know, based on substantial records that aren't like speculative at all, that this gentleman self-admitted numerous times to being a drinker over a numerous period.
No, I,
And
that part of the case, I know you've told me that many times.
Right.
Like, he drank a lot of alcohol according to you all, okay.
Right. But the point is that's what experts are going to argue and try to help the jury understand. And defendants should be given the opportunity to help the jury understand their viewpoint of whether or not the defendants harmed this plaintiff. And it should go to the weight, Your Honor, as you were inclined to rule initially.
Thank you very much.
Thank you.
Any reply?
Yeah, sure. You zeroed in on it, John. I want to start off where Mr. Cavanaugh left off. Oh, I apologize. I'm sorry, I apologize. My friend Gina would like to speak.
Okay.
Good afternoon, Your Honor. Gina Mushmeche also for Real Water. The one thing I wanted to point out is, as Mr. Parker mentioned this in his arguments, and I want you to understand the Shaparov plaintiffs, we did hire hepatologists to address those. But once you consolidated the Herbst case with the Shaparov case, everything was moving quickly. So that's why we joined Nevada Beverage and Terrible Herbst regarding doctors Tenor and Atchison. So, obviously, Mr. Cavanaugh has provided your argument. I'm not going to repeat anything, but I just wanted you to understand that. That's the only thing I have. Thank you.
Again, Your Honor, I want to start off with Mr. Cavanaugh left off. Shane, could you please put on the screen deposition testimony from Dr. Atkinson? Your Honor, this goes to what you were saying earlier, and I'm going to circle back to the substantial factor, the eggshell. That's the Price case that you were thinking about, Your Honor, 1995 case. It says here, if there's 5 different people, one of them is going to get cirrhosis from drinking alcohol. The other 4 can drink alcohol. There's no way of telling who is more likely. Then this is the question, and the answer says, I don't know. I'm not an expert on alcohol causation of cirrhosis. Your Honor, he's saying he doesn't have the foundation. You don't have to listen to me anymore, or Mr. Cavanaugh. The doctor himself has said he lacks the foundation to give a causation opinion on alcohol. That rules Dr. Atkinson out. And I appreciate good briefing, and I understood as soon as the court said what it said, what had happened with that opposition, and I give them, the golf clap on that.
I know you love their argument.
I did. Until you put it against the actual facts and the deposition testimony of Dr. Atkinson. He himself disqualifies himself under Hallmark, Your Honor. Plain and simple. And when you consider Tenor, Your Honor, it's no different. Tenor has been excluded on every case, just like Dr. Atkinson, because they come up with speculative reasons why it cannot be hydrazine. It just can't. That's what they say every time without considering it. And that's the death knell, the fatal flaw in their positions under Williams. You cannot provide an opinion that completely ignores the causation opinion of the other side without giving your opinion to a reasonable degree And they've not done anything in terms of what caused his cirrhosis. Dr. Tenner says he does not know. That's he said it's pure speculation. His opinion was because 10% of alcohol drinkers suffer cirrhosis, that could be the only thing that caused Mr. Herbst cirrhosis. Your Honor, he does not have any opinion based upon anything other than that. And the other thing is, in addition to him being disqualified 3 times for his creative causation suggestions, Your Honor, one thing that we've discussed in other motions, the substantial factor under the restatement second of torts, 402A and 431, I believe, Your Honor, is that it doesn't have to be the sole cause. It could be additive, it could be synergistic, it could be one of 2 causes, it could be one of 3. Because they never considered it, their opinions can't come in. The other thing I would point out, Your Honor, and this is really, it takes me back to the case we had before, Your Honor, in the Wren case. None of those babies drank alcohol, Your Honor. And they all had some form of liver failure. All of them almost necessitating liver transplants. Severin, the one you became very familiar with because we had slides, had cirrhotic nodules. Both of these experts say, this is their foundation, that real water can't cause cirrhosis. And they, in particular, real water out of retail bottles. But they give you no explanation, anything that would assist the jury to say, well,
May put this one back on for additional argument, or I may just issue a minute order. Let's put yeah, and my paper calendar up here is still in 2025. So bear with me a moment. And this is not counting against either side's time right now, just so you know. Well, let's optimistically put it on for Chambers on Wednesday, the 14th.
That'll be January 14th in Chambers.
Okay.
can I make a recommendation, Your Honor? I don't believe the defendants will object, but let me take a shot at it if I could, Your Honor.
Sure.
Given that the court is taking this one under advisement, Mr. Cavanaugh and I discussed arguing in part 3 and 4, number 2 in terms of, I'm sorry, 2 and 4. In terms of number 3, real water, I think we've come to an accord on that one. In terms of real water, we are agreeable in that real water's case-specific experts agreed that in terms of all of the plaintiffs, not including Herbst and not including the babies or the children, all the other ones, I think there are 8 or 9. We would stipulate to causation. They're stipulating causation. I think the court really, by a motion for summary judgment on the 3rd, really kind of ended that. But their experts testified during deposition that they suffered liver injuries due to their consumption of real water. So I think that takes number 3 off the plate, Your Honor.
Anybody have anything on that?
Yeah, I don't disagree, but do want to clarify. So as it relates to number 3, our experts have testified for the non-wrongful death and non-child claimants that hydrazine from real water caused their acute illness. We will dispute futures and the extent of those damages and what their pain and suffering consisted of. But as it relates to the acute illness period, our experts are in agreement with theirs. So we do stipulate to that portion of the motion.
And I apologize, which
That is number 2,
3.
number 3, Your Honor. I'm sorry, number 3 on the list.
Pre-admit FDA.
No, I'm sorry. It's 3 on number 3 on our list. I apologize, Your Honor. The name of the motion is plaintiff's motion for summary judgment as to plaintiff's claims for strict product liability and causation against real water defendants, and that the real water defendants sold an adulterated product. That one we've reached an accord.
Okay.
I believe there's already an order that the product was adulterated, so there's no point in arguing that.
Well, that was one of my inclinations. Okay.
Well,
I think it comes back to the estoppel,
Oh,
everything from
the
December 3rd, John.
summary
Exactly. Right.
judgment, okay.
That's correct, John. And so my thought is, Your Honor, given that you've taken this one and advising, when I asked Mr. Cavanaugh about this, we could probably push 2 and 4. Certainly, Your Honor,
So when you say to be more specific, so
Yes,
I
Your
don't get confused again.
No problem, Your Honor. So plaintiff's motion as for summary judgment as the plaintiff's claims for strict product liability and causation against Nevada Beverage Company, which we know is out, and ETT1 LLC, DBA Terrible Herbst, and the defendant sold an adulterated product. You've already said your inclination in terms of the part 2,
Uh-huh.
but because the causation issue is in part tied to Atkinson and Tenor, this may also, I believe, be dispositive of that issue. So I would just say that because we both want to argue, we just push that one until we get the court's decision that's being taken under advisement. Mr. Cavanaugh may have a different opinion, but to me, it makes sense. You know, I'll wait to hear what he has to say.
I don't want to get in the way of progress, Your Honor, and I promise you, please take my word for it, if you can. I would like to hear the court's thinking more on the preliminary ruling. I thought on number 2, the second part, so number 2 being the second one in the list of matters to be heard today, it's plaintiff's MSJ on causation against the Terrible Herbst and Nevada Beverage defendants. And the second part was on the whether or not defendants sold adulterated water. So it's the second one on the list here. And that does, that's the flip side of our argument in the fourth one, which is on the list today, which is joint defendants motion for summary judgment based on causation. Your Honor is inclined to deny in part, grant in part, both of those. Well, actually, no, the first one
I
was.
think on yours, I was inclined to deny, right?
Yes,
Okay.
yeah, I misstated that. You're right, Your Honor. On the plaintiff's MSJ, inclined to deny the causation argument and grant the second part, the adulterated product argument. With regard to the fourth matter on for today, the joint defendants motion for summary judgment regarding causation. We wanted to hear the court's thinking on that. You were inclined to deny it without prejudice. I had told counsel outside in our meeting conferring that we would go ahead and argue that, if only to get the court's clarity on the ruling on the joint defendants motion for summary judgment.
Okay, so I could tell you on what you're referring to as number 4, joint defense motion for summary judgment against Herbst plaintiffs on issue causation. This is probably not going to sound the best, but at least I'll be honest. This isn't even a close call. That it kind of goes back to my comment earlier that I struggled to actually formulate a question from. The defendant's arguments and position are difficult for me to understand, because they seem to discount entirely the substantial factor eggshell plaintiff issue. And so my note is just a little clearer. It's, genuine issues of material fact, see plaintiff's opposition. Again, this one's not even, if I thought it was a close call, I'd have more specific reasons to give you. But it's, you know, again, my note says see plaintiff's opposition. I, yeah, this is the one where plaintiff's opposition went through and we kind of talked about this in other hearings, you know, all the evidence that, you know, Mr. Herbst drank real water, where he got it from, and the causation issue, then medically the causation issue goes back to me anyway to eggshell plaintiffs and substantial factor. So I'm sure that's clear as mud to you, but I don't know what else to say really.
Well, the choices here, if counsel would like to continue the argument, or if the court would be inclined to listen to it, I understand better now the court's thinking on the medical part of causation. And of course, if two sets of experts are disagreeing, it's hardly a summary judgment motion resolution there. Because they're both allowed to have those opinions if they're qualified under Hallmark. But the biggest part of our motion, Your Honor, happens way before any expert analyzes the effects of real water or the eggshell theory of what came first.
Well, see, the what came first is that. So this is where I struggle, and I'm not sure if it's my, you know, lack of being articulate. It's a possibility. I'm not sure what came first really matters. In terms of you have somebody who you're arguing, you know, drank a lot of alcohol and the alcohol is what caused his cirrhosis. Fine, but even accepting that argument doesn't preclude plaintiff's whole case, which is, yeah, we know he drank a lot of alcohol. We disagree that it caused cirrhosis maybe, but that really doesn't matter a whole lot because it's a substantial factor in eggshell plaintiff. So the chicken versus the egg, I don't quite follow. But if it's, we want to argue what you all refer to as MSJ number 2 and number 4 next week, that's fine by me.
Could I be clear on something, Your Honor?
Sure.
There's two parts to the argument, and what I'm proposing is the court can disregard the medical part of this, the eggshell plaintiff issue doesn't enter into it if Mr. Herbst never drank the water, or at least what we're arguing.
But there's a lot of evidence that he did. And I know you disagree with that, but there's no way I can say summary judgment for you because he never drank real water. I mean,
understand that.
Okay.
I just want the court to understand that all of the direct evidence, there's no documents, none of the 11 witnesses identified in discovery by plaintiff have witnessed this Milo Herbst having drank real water that he obtained from our client's store. That happens.
So there's a jury instruction that says flat out, you jury can consider both direct and circumstantial evidence. You're entitled to give equal weight to both types of evidence. The amount of weight you give to any particular type of evidence, whether direct or circumstantial, is up to you, jury. Yeah, they could decide that the plaintiff Milo Herbst hasn't shown that he drank real water obtained from Terrible Herbst. They could also decide based on all the circumstantial evidence that he did. So
So we're inclined to follow Mr. Parker's recommendation to forego further argument on those two, with the understanding that the court's initial inclination is to deny without prejudice the ETT one Terrible Herbst motion for summary judgment on causation, given the court's explanation and
So,
the fact that, again, jury instructions can and/or argument during trial is not precluded. It's just not, it's denied without prejudice as to our motion for summary judgment
on,
against
on
plaintiffs.
causation, right?
On causation, yes, Your Honor.
Okay, so that one's denied without prejudice because genuine issues of material fact exist. See in particular details set forth in plaintiff's opposition. Okay,
Fair enough.
Thank you, Your Honor. And so that would only leave for us now, Your Honor, to hold into in abeyance our motion number 2, which is plaintiff's MSJ as to terribles, once the court makes a decision on Tenor and Atkinson.
I would respectfully say Tenor and Atkinson are two of several experts that are involved in the causation issues. But again, I'm not wanting to get bogged down in medical causation here. I understand the court's thinking on this, and so we're going to defer any further argument and accept the court's ruling on plaintiff's motion for summary judgment against Terrible Herbst on causation.
Okay, you just confused me, Your Honor. I'm sorry, Mr. Cavanaugh just confused me.
so I was inclined on,
You're inclined to grant that one? In
well,
part,
yeah,
that's right.
sold
So,
an adulterated product
exactly.
to
And-
grant and then deny in part the causation.
Exactly. And so what I suggested, Your Honor, because if Atkinson, keep in mind, Your Honor, real.
You all
water is-
are taking a lot of time here.
We're not gonna take much on the others.
I'm done, Your Honor, if you're done.
So, Your Honor, I apologize, but let me just clear it up. Real Waters experts, Cohen and Sato, offered no opinions in terms of Mr. Herbst. So when Mr. Cavanaugh said what he just said, there's only only experts retained by Terribles, Atkinson and Tenor, to try to provide opinions, which we believe they lack foundation for. Now, if Your Honor is already
Okay,
informed us
well,
you're taking an
number
advisory.
2. Well, let's
We can just
argue
put-
that next week. if
Sounds
you
good,
want.
John.
Okay.
Thank you, Your Honor.
Now we're on the same page. Thank you, Your Honor.
Good job.
You got convoluted, but I apologize.
Which one are we doing now?
So.
Your Honor,
They may tell us something different. So wait.
plaintiffs' motions eliminate 2, 3, and 5. We do not need to argue. We'll go with your inclination to grant.
Okay, so thank you. So plaintiffs, motion limit 2, 3, and 5 are granted.
I'm sorry.
You're
Oh,
exactly right.
Oh, okay.
Well, this should say. One of them might be misnumbered. Okay, so place motions and eliminate which numbers of the motions and eliminate?
2, 3, and 5.
2, 3, and
2
5.
is to pre-admit the government reports, 3 is to pre-admit the FDA concentrate testing, and 5 is to pre-admit the Eurofins testing.
And that's the ones you're talking about.
I'm sorry, I was distracted talking to you.
2,
2, 3, and 5. Your Honor.
2, 3, and 5. Okay, those are all granted.
Thank you.
And
Thank
then I
you.
believe there was actually one inadvertently skipped, and that would be our plaintiff's motion for summary judgment that the medical expenses. So I know your Honor had a question on this one, so we'll focus on kind of narrowing down on that specific question. So this is plaintiff's motion for summary judgment that the past medical cost be determined for the lack of issues of material fact. What your Honor was kind of talking about when you brought up the inclinations was is this premature and kind of tied into with causation. We argue that these are kind of separate. So this is a separate issue related to just the past medical damages. These are if the jury strikes the box, if the court strikes the box. Obviously, we already heard there are several plaintiffs that already liability and causation are already determined. So this is a separate and apart from that. So this means that if causation is established, these are the past medical damages that would be awarded and added to the judgment. So if there is no causation for some reason that is determined, then that wouldn't impact anything. And that's why this determination can be made at this time. And actually why Your Honor may not be a reminder of this one in the past is because actually Real Water stipulated that this one could be granted previously. And this one was granted in every single one of the cases. And the reason for that is because there is no other expert testimony. There's no controverting evidence. If you looked at their opposition, there was no affidavit, there was no declaration, there was absolutely nothing cited in their opposition confronting plaintiff's prima facie case.
So basically, plaintiffs are saying if causation is established, court, you then have our past medical numbers. The jury doesn't even need those, right?
Correct. Yes, they're unrefuted, they're not disputed. There's, we've met the case on this. There's no reason to bring this to the jury because it is undisputed. And so that's by and large, I wanted to answer the court's question on that regard.
So, what about Mr. Herbst?
So as for Mr. Herbst, it's the same thing. So if for some reason that either the court or the jury finds that there's no causation, then these damages is just a number. However, if the jury does strike the box, these are the numbers. And the reason that is our expert has looked at them all. Our expert went and said they're reasonably necessary and tied to his liver injuries. There was no alternative evidence that they presented related to that. They did not question our expert at the time of his deposition. There's no affidavit, there's nothing. So it's the same issue as all the other plaintiffs. If for some reason the box is not marked, it's just an outstanding issue. If the box of causation is checked, then this is the amount of past medical damages that has been established in this case are undisputed, and defendants have not provided any contrary evidence of the same.
Thank you.
Thank you.
Any opposition or oppositions?
There is an opposition, but it's kind of just a discussion. Okay, we don't disagree, it's reasonable, customary, and necessary. But with regard to Mr. Herbst, by way of example, there was a comprehensive cancer bill of substantial amount that has nothing to do with Real Water. So we're simply pointing out that while we're agreeing the numbers are accurate, we still need the jury to allocate items that are not related to Real Water. So by way of examples, the cancer, that's something that's completely unrelated.
So, with the other plaintiffs, do you have any issues?
The other plaintiffs, no issues.
Okay.
Just Herbst.
Okay,
Thank you, Your Honor.
thank you.
And Your Honor, I don't know. Oh,
Wait, hold on. I was gonna say, I'm thinking somebody else from the other side.
Good afternoon, Your Honor. Brad Johnson, on behalf of the Real Water Defendants. Your Honor, position is pretty straightforward. It's really on the Herbst claimant that the issue is present without causation, then we don't go to specials. And that's basically what counsel stated is if they find, et cetera. But however, they're putting forth, I believe, over $1 million as it relates to Mr. Hirsch. And I believe that's what Nate was talking about is there is the dispute as to whether all that would be related to Real Water. And that's the question of fact. Also, just so it's clear for the record, there are no medical records for the Shaparov children. So that's not an issue in the context that we're not stipulating to those meds. That may be self-evident, but it may get lost in the shuffle. Hey, we agreed to everything. Because the other individuals who are still in the case, my client, we stipulate to that care is reasonable and necessary. Thank you, sir.
Thank you.
Just briefly, Your Honor. And specifically as to Mr. Arrington's point, he mentioned the cancer records, and actually, if you looked at our motion, it starts on page 2, sorry, Shannon told me 3. It says the only medical costs mentioned at Dr. Khan's deposition were related to the comprehensive cancer of Nevada. These costs have been withdrawn and are not included in the above figure. So that's actually specifically put out in there. Everything else is in there. Should they have our computation of damages is in there. To the extent they had any question as to this, it was their responsibility. If they didn't meet their burden, there's no expert that shows it. They didn't dispute anything. No actual individual cost is actually even mentioned specifically in their opposition. Really, what we have here is a clear issue. Past medical specials, our expert opined as to them. He wasn't asked any questions besides that one that we withdrew, as you see in our motion. There's nothing else to counter that, and our motion should be granted.
And you agree that the Shaparov children are not?
They were not included within the scope of the motion. We didn't put their names in there, but to the extent there was any clarification, we can clarify that.
Thank you.
Thank you.
So granted is to everyone but Mr. Herbst. So yeah, if causation's established, then here are the past medical special expenses. Mr. Herbst, it's unclear to me that you know, this goes back to issues we talked about at many other hearings. But he's part of the trial, so and it may be that, there are potential issues of material fact, potential genuine issues of material fact with Mr. Herbst, and maybe the calculation's correct, maybe it's not. I don't know as I sit here. So I changed my mind at least. Okay, next.
The next one, Your Honor, is plaintiff's MIL number 6, I believe.
47.
Oh, 47, Your Honor. This is a CDC. You know, this is more of a clarification. I don't want to spend a lot of time on it since I spent a lot of time on the other. Your Honor, despite the fact that you're inclined to deny this one, is it still your position, Your Honor, if the other side believes they have a good faith belief that the document will come in during trial, and it's their risk that they take by bringing it in and an opening?
I'll say that I didn't
Sure.
quite follow, sorry.
Sure, a lot of judges, Your Honor, and I think you're included in this. If a party believes that the documents will come into evidence, they got good faith belief, they can still use it in their opening.
Correct.
All right, I just wanted to make sure.
Yeah, and okay, so your question, you know, you run the risk of, you know, putting up an opening, hey, this is what you're gonna see, and then if it's excluded, you don't see it, yes.
That's correct.
So but I should let the defense respond as well.
Your Honor, I don't want to spend much time on this issue either. I think your inclination was correct, and I think if the plaintiffs wish to use the documents in their opening, they do so at their own risk, and we're comfortable with that.
Okay.
Thank you,
Yeah,
Your Honor.
thank you, thank you. So to be clear, that one is denied without prejudice, and with that clarification. Thank you.
So Your Honor, the next one is MIL, plaintiff's MIL number 6, which is to preclude real water toxicology stealth plug. Offering opinion that there was insufficient hydrazine in real water to cause liver damage. You see that one?
Yes.
It's a long title, so I stopped in the middle.
Yeah.
So Your Honor, on this one, we, as you know, the motions in limine were filed before the court's hearing on the 3rd of December. So if we had had that ruling, we probably would not have filed this motion. The court's decision on that motion for summary judgment, from the estoppel arguments, Your Honor, really makes this a moot issue in our opinion.
No, wait, wasn't it preclusion and not estoppel?
Yes.
Okay, see, I do remember
That is
some
correct, John.
things, okay.
That is
People
correct.
still call it collateral estoppel instead of issue. preclusion.
Yeah, cause, but I
Gets
think
confusing.
we have an estoppel motion still kind of hanging out there, right? See, the person who knows most, yeah, okay.
That's correct, John. And as you recall, Your Honor, the real water defendants in every other case is stipulated to this. When they didn't stipulate, we had motions for summary judgment granted. And so there's your decision on the third, in my opinion, makes this moot. Steflug comes in and says something that's completely inconsistent with the decision of the court and what will be now.
Well, is the opinion only as to Milo Hurst is?
No, this is
one
generally.
might-
This one is generally. I mean, it really deals with Milo Hurst because it's the retail bottles, but he speaks to whether or not there's sufficient hydrazine in real water to cause liver injury. And then he says, he compounds it by saying to cause liver failure like death. And as you remember, the very first trial we had, the Gallagher trial, Miss Kathleen Ryerson died. And real water ultimately stipulated to the trial. So we know that it can cause death. We know that it can cause liver transplants. We've had 2 of those in relatively young males. We know it can cause cirrhosis, cirrhotic nodules in an infant. So his opinion, without really any foundation, is that real water can't, does not have sufficient concentrations of hydrazine, which again is inconsistent with real water's on other experts. Cohen and Sato, as you already heard a little while ago, Your Honor, have already indicated that the causes of those injuries were real water containing hydrazine. So they can't have another defense expert come up and contradict their own experts. And quite frankly, Mr. Steflug doesn't have foundation. He's done no testing. He's not tried to recreate the cause of the hydrazine in real water. He's done nothing scientific that could be checked. So if you were to apply Hallmark and the factors under Hallmark, Your Honor, he certainly should not be allowed to come before this court. And as a gatekeeper, Your Honor, we ask that he not be allowed, given his testimony. If you like, Your Honor, I know you've read the papers, but I can allude to some of the deposition testimony.
I would save it for rebuttal. Let's hear what they have. to
Will
say.
do, Your Honor. Thank you.
Your Honor, Jim Cavanaugh again for ETG one DBA Terrible Herbst. To be clear, we disclosed Dr. Stelflug and the real water defendants as it pertained to Mr. Hearst's claims joined. And the problem with plaintiff's motion limiting number 6 is that it refers to these other doctors, Cohen and Sato. Number one, neither Drs. Cohen or Sato opined at all, considered any of the issues with Milo Hurst. They have no opinion on
So
Milo.
let me ask you, because yeah, this is one, but because I asked plaintiff's counsel, is this expert only opining as to Mr. Hearst? He said, no, this expert's opining as to every plaintiff. And I'm not sure you agree with that or not.
Yeah, I think counsel is mistaken. And if he takes another look, he'll realize they were only co-designated by the real water defendants after we designated Dr. Sam Stelflug, who is eminently qualified medical toxicologist with double board certified, full professor of medicine at University of Minnesota, clinician, and as much as any expert in any of these spaces has, he's looked at all the test data.
So
and
my question
is qualified, but
so this goes, so is he even for your client's designation of him? is he going to come in at trial? Or is your plan, or however you want to put it, and opine as to every plaintiff or just as to Mr. Herbst?
Just as to Mr. Herbst and only Mr. Herbst. Those are the only records in matters that he's considered. He has no opinions regarding any of the other Shaparov case plaintiffs. No.
Okay, that's
Zero.
what I thought, but
So the title to the motion is referring to Sato and Dr. Cohen. If you read it's a long title.
yeah. Okay.
He has, we've not retained them. They were retained many years before we were brought in the case 10 months ago or 8 or whatever it was.
And I cut you off.
No, I'm sorry. Did I answer your question, Your Honor?
Yes.
All right. And I don't know if what your prior inclination was to deny based on weight and so forth, but I think there's been some confusion here, so I think hopefully it's straightened out
Thank you.
as to that motion. And limine. Thank you, Your Honor.
Thank you.
I think Real Water has something.
And Gina Mushmeche for Real Water Defendants. Briefly, Your Honor, that's correct. Dr. Stelfledge was not asked to do anything regarding the Shaparov plaintiffs. End of story. We did join, just like we did with Doctors Atchison and Tenner, but specific to Dr. Stelfledge, we believe he can testify in this case. We believe his testimony or his opinions, or you allowing them, would go to weight, not admissibility, because if there's a lack of evidence that Milo Herbst consumed real water, then as a toxicologist, he can offer opinions that this is insufficient to cause a liver injury. And from that standpoint, he opined to a reasonable degree of medical certainty that retail real water would not have caused end-stage liver failure. And if Milo Herbst consumed some, which that's a matter of opinion on both sides, it wasn't enough to cause cirrhosis, and certainly not over the time period that Milo Herbst developed cirrhosis. So I'm confident that plaintiffs at trial would cross-examine Dr. Stelfledge, and some of the questions they may show you in a rebuttal are questions that were asked during the deposition by plaintiffs' counsel regarding Shaparov plaintiffs. But again, that's not what the defendants are planning to do. So if they want to impeach, they want to cross-examine, that's up to them. But we are not offering this witness as an expert as to the Shaparov plaintiffs. Thank you, Your Honor.
Thank you.
And I appreciate the clarification that you have been able to get out of the defendants on this. The deposition stands for something different. Shane, can you put that on the screen, please? Your Honor, looking at the deposition, page 121, 12 through 122, 19. I don't know if that's big enough for the court to see. Shane, is there any way, because I can't even see it well, actually. The question was asked of him, Your Honor, on page 21. It started on page 17 and 117 and 118, but then it went down to 121 and 122, and it says, "My opinions are what they are. I've stated with thorough examination and justification that there isn't enough real water or enough hydrazine in the bottles that were consumed by any of the plaintiffs to cause liver damage." So while he may intend to only give opinions about Herbst, that's not what he said during his deposition. So that may be cause for the confusion. In terms of Mr. Herbst, Your Honor, again, his general opinion is there's not sufficient hydrazine in real water to cause liver injury. And Your Honor, this has not changed since the Wren case. He's not tested any bottles, be it the concentrate, the jugs, or the retail bottles. He's run no tests in terms of recreating the formulation, the recipe used to create the concentrate. And he comes in after we have already heard stipulation here and the court's finding on December 3rd that real water is a defective product, unreasonably dangerous. based upon the prior summary judgment against Terrible Herbst, that hasn't changed. There's no way they can skirt around it. In their opposition, they don't address it. There's a reason why he's not been able to take the stand in these cases, Your Honor. And there's a reason why summary judgment was granted by Judge Kishner, and why on 5 cases involving 46 plaintiffs, they stipulated, if not through a motion for summary judgment, has been decided that real water has hydrazine in sufficient concentrations to cause liver injury. In the Ryerson case, it was death. In Watson, it was a liver transplant. In Brown, it was a liver transplant. And in front of Your Honor, in Wren, cirrhosis in an infant. So, Your Honor, he does not have the qualifications. In terms of foundation, I shouldn't say qualifications. In terms of foundation, he's not done the work. I don't want to misspeak.
No, that's a fair distinction.
Thank you, Your Honor. And again, Your Honor, to say that it's impossible, given that Cohen and Sato, in this case, in addition to, of course, your December 3rd decision, Your Honor, prevents him from taking a stand, Your Honor. And he's given no other causation opinions in terms of how hydrazine could have gotten in the water and what concentrations there were in the water. Thank you.
So I can rule in part right now, and then we'll have some additional argument. So defendants have all clarified, whether you call it stipulated, agreed to, or whatever else, that he's only, and the court so orders, so this is a court order. He's only limited to Mr. Herbst, so none of these general opinions about any other plaintiffs. Now, what I want, I've got to pull his actual report up because I didn't print tens of thousands of pages for this. So if his opinion is actually that there was not or is not sufficient amount of hydrazine in the retail bottles sufficient to cause injury to anyone, including Mr. Herbst, then I think he's excluded. Because I mean, I've ruled differently already, essentially. But I want additional argument after I pull up his actual report. So give me a moment to find that. Might be more than that.
We can put it on the screen if you like.
Does anybody have a document number? I assume it was attached to your motion, right?
What is your honor? What's that?
Do you need an exhibit number, Your Honor?
Yeah, well,
document. Why don't we can email it to you, Your Honor, that way you can print it out in a break if you want.
Yeah, let's go off the record and see if we could figure this out off the record. Okay. So the court certainly, to repeat, granted in part in terms of Dr. Stelflug cannot is precluded from opining that there were insufficient amounts of hydrazine in real water to cause injuries to plaintiffs, all the plaintiffs other than Mr. Herbst. Mr. Herbst is the issue really here, and Dr. Stelflug opines generally that there was insufficient hydrazine to harm anyone, and that's excluded. That ship has sailed many times already previously. As to Mr. Herbst, I'm going to deny it without prejudice. The reply wasn't the most helpful in terms of addressing an argument that what I ruled on December 3rd would exclude his opinion even as to Mr. Herbst. I'm not sure that argument's correct. It just wasn't fleshed out enough for me. So if you want to file, a trial memorandum or whatever else you can think of on that, that's fine. But for now, it's denied without prejudice as to his opinions on Mr. Herbst. Yeah.
Thank you, Ron.
Thank you.
Thank you, Ron.
Okay, what?
The next one I believe is Plaintiffs motion number 8 to pre-admit real water epidemiologist Dr. Goldsmith. It's my understanding that the real water defendants would like to argue this one. I'm going to save all my time for just rebuttal remarks based on the court's inclination.
Okay.
Thank you, Your Honor. No, I'm not objecting to the use of Dr. Goldsmith's deposition consistent with that set forth in NRCP 32. What I object to is if you looked in their motion, that what they want to do is display quote unquote small portions, close quote, of his testimony during opening arguments. Though that is my objection. And I understand, and it's been drummed into my head numerous times. So we've used this expert numerous times over and over again. All those issues were, I assume, by way of motion and limine, and those were granted without prejudice, and you can always object. Your Honor, I don't, we had the last trial we had in this case, my opinion, it was like a cowboy show. There was objections all over the place. I don't want to be objecting to somebody's opening and things of that nature, but clearly, if they're going to give me an unknown small portion of a deposition testimony, when this witness is otherwise available or doesn't meet the or can be, his deposition can't be used like he's a party, per the rule, then I'm going to object. It was my understanding is that the portion of his deposition they want to use was refuted in his supplemental report saying that particular testimony, if I'm assuming is what they're talking about, was taken out of context, etc. Then that's objectionable. It's not something that went by without objection. Additionally, it confuses the jury and is prejudicial to our case. The jury is going to be confused as to who is this individual? He's their expert, he's our expert, typically is laid out in the context, even their expert agrees with us, etc. And that's simply not the case. So as it relates to an opening argument, I'm certainly understand, and everyone here is very sophisticated, and everyone here has had decades of experience, and we're all gray haired and everything else. And we understand that you can state in your opening argument, hey, here's what I believe the testimony is going to say. Their expert agrees with us, things of that nature. But using his deposition in this way, I believe is improper for the reasons stated. And for that reason,
So
I'd ask you to reconsider.
So would at least part of your concern be addressed if they were to identify
That would be
particular
helpful.
portions?
Sure, that would be helpful. And so perhaps we can do that. I think that's the real argument rather than standing on quote unquote the rules. Let's get this case going. Openings are important, but by the same token, my client has to be protected and I have to know what's coming down the line.
Thank you very much.
Thank you, Your Honor.
Your Honor, we believe that obviously your initial inclination is correct. As to Mr. Johnson's concern, obviously opening statements are a spot where we can do that. I know he had concerns about the actual individual designations, and that's what this court has already said. We've actually already disclosed our designation for Dr. Goldsmith. It was part of our pretrial disclosures that we produced about 2 weeks ago, I think, at this point. Sorry, the dates are kind of blending together, but we have already made those designations. It is very clear that Dr. Goldsmith is relevant, admissible, probative, all the fun stuff. They're not unduly prejudicial. To the extent that counsel believes that there's some misclarification, they have their opening statements in order to provide any counterpoints that they would like to address, any clarifications that they think plaintiffs missed up. just because we have it in our opening statements doesn't preclude them from addressing anything like that. So with that regard, Your Honor, unless you have any other questions, we believe your initial inclination is correct.
So I might have a question or two as well. One of the concerns, and I mean, I'll be candid, I struggle with this if you all already can't tell, which I'm sure you can. You know, who is who and which witness is testifying for which party on behalf of or against which plaintiff. Any issue with being specific as to who Dr. Goldsmith is and has been retained by prior to putting up his depot and opening.
And I believe in opening statements, we make this clear. And the reason why, defense counsel now has a problem with it is because Dr. Goldsmith was hired by the real water defendants to make his opinions. So I think plaintiffs properly say, Dr. Goldsmith was hired by the real water defendants, and these are his arguments.
Okay.
And that's how it's come up in the past trials. That's how we've done it. Dr. Goldsmith has testified via deposition in all 5 prior depositions. And we've done similar motions related to the same as this, and we always classify it like that.
And then in terms of the designations, would you be planning on putting up portions that there were objections made during the deposition?
I believe that we haven't done that in the past. If it has been objected to, we've either sought rulings before we played it in openings or otherwise try to handle that beforehand so that is a non-issue, is my recollection. So obviously we would not purposely intend to play deposition testimony that has objections to without trying to seek guidance from the court or otherwise knowing that we're running into a potential question mark and or gaining an objection at the time of the opening statements.
Okay, so now you'll have an order. Granted in part, well, let's say, I mean, it's granted, not in part, but granted with clarifying requirements. One, plaintiffs are to be clear as to who Dr. Goldsmith is, and in particular, who he was hired by, designated by, retained by, whatever word you want to put in there is fine. But yeah, with multiple defendants, multiple parties, plaintiffs are required to be clear as to, not retained by, somebody who's, don't use a generic word like defendants plural or they. In terms of without a further court order, plaintiffs are precluded from using his deposition and opening to put in front of the jury any question that was objected to during his deposition. As I sit here, I have no idea what was and wasn't objected to in his deposition. Oh, and they're limited to what's been designated in the designations, because that I think is fair notice. But to the extent any of those designations have questions that were objected to, you can't put them up in front of the jury in opening without further clarification or order from me. If you do, you'll be in violation of my order.
Thank you, Your Honor.
Thank you. Okay, next. We want to talk about the plaintiff's motion order number 9, Scott Donnelly, or did you reach an agreement?
Nothing from the plaintiff on that one, Your Honor.
Yeah, I'll reserve on that one, Your Honor.
Your Honor, we're asking to address the court on this one briefly.
Oh,
just to give
sure, yeah.
some clarification more than clarification. And Your Honor, for the sake of the record, the same issue comes up in plaintiff's motion limiting number 9 and plaintiff's motion limiting number 10. There are two experts here, Scott Donnelly and Catherine Donnelly. They are husband and wife, but they do serve different functions and provide different testimony. So complementary but distinct.
Sure.
And I think that's important here because for the purpose of these two motions, what Catherine Donnelly refers to and what Scott Donnelly refers to are being opined upon for different purposes. And so I just want to touch base on that and see if it influences the court's inclination whatsoever. As a threshold matter, however, Your Honor, we are aware that the court has already ruled that the real water in question here that may or may not have been consumed by the plaintiffs was defective in nature. That creates a little bit of a complication as to how viable Dr. Najim's testimony, the plaintiff's chemist, is going to be in this trial in the first place. And as Your Honor knows, what the issue that is core to these particular motions in limine is the concept of how did the hydrazine get produced in the first place, and whether or not that Dr. Najim's opinion as to the pathways is sufficient enough to establish the levels of hydrazine that were detected in the testing. So that's important because plaintiffs rely upon an independent alternative causation argument in saying that these experts cannot opine on these topics. The problem with that is not just under Williams, but under Levitt, that's not what the Nevada Supreme Court has said, because that, first of all, that line of case law refers to medical causation. And if Your Honor will recall during the issue preclusion hearing, because the court got to it before I did, there is a distinct difference between medical causation and liability with regards to whether or not the product's defective in a product liability suit. So I think one problem that we have here with regards to the motion is that we're once again going back to the well and conflating these two issues. But the more important issue is that under Levitt, the Supreme Court was very clear that speculative testimony is appropriate under certain circumstances. And I think it aligns very closely with the nature of the testimony that's being sought after here. And Your Honor, if you don't mind humoring me for just a second. Under Levitt v. Seams, 130 Nevada 503, this is a 2014 case. The court states, and this is at 510, we further conclude that Dr. Hansen, who was the expert in question, properly testified as to his opinions and inferences to rebut Levitt's theory of causation, and that even if portions of his testimony were speculative, it was for the jury to assess to the weight to be assigned to his testimony. What the Nevada Supreme Court has said is that defendants are offered a variety of different paths to rebut a causation opinion. Independent alternative causation is one of them, but it's not the only path forward. And the Supreme Court has taken a very broad and somewhat relaxed standard for allowing rebuttal testimony or even defense expert testimony generally in saying, yes, plaintiff's expert may be right. That may be a cause, but it's not the only one. And in fact, Williams brought that point to a head. And this is obviously the case that Levitt built off of. And Williams actually decided that it would be, and I'm quoting here, manifestly unjust and unduly burdensome on defendants if the defendants were required to meet the level of specificity that a plaintiff's medical causation expert is required to meet in order to establish an alternative causation. So the problem with 9 and 10 here, Your Honor, at its core is that one, we're not talking about medical causation to begin with, right? When we're talking about what Scott Donnelly opines on, he's talking about how hydrazine was created. That goes to the product defect. That doesn't go to whether or not the hydrazine injured the plaintiffs. We're talking about Catherine Donnelly. She is opining as to the Superfund site with relation to the nature of the FDA or the EPA inspection, excuse me, and problems that came up by the failure to consider other possible contaminant sources. So quoting Williams, it's the purpose of the testimony that matters. And so really the reply tries to reframe, to borrow from Counselor Parker here, reframe the argument in a way that says, well, no, we're talking about Dr. Najim and causation. I think at one point they say, well, the word root cause analysis is in there, so causation must be the issue. Well, that's a red herring. At the end of the day, what we're talking about here is dependent upon each expert, but it meets the Levitt standard for saying, no, we're not talking about medical causation. And even if we were, what these experts are saying is that there are other alternative considerations. even if those aren't to the same degree of medical plausibility that a plaintiff's expert is supposed to argue, at the end of the day, under Levitt, that testimony should be appropriate. So when it comes to the substance of the arguments under motion limine 9 and motion limine 10, Your Honor, I'm happy to answer any questions about the specific opinions of the experts.
Let's
Or anything
stick
else?
with, let's stick with 9.
Sure.
So a large part of why I'm inclined to grant 9 on Mr. Donnelly or I apologize if he's a doctor, but Scott Donnelly, is the lack of qualifications. So what's your argument
Sure.
as to that?
And Your Honor, I anticipated that would be an issue the court wanted to address. Scott Donnelly has a PhD in microbiology. Scott Donnelly has worked for Wyeth Laboratories. He's conducted his own testing. He has overseen multiple HACCP protocols, root cause analysis, hazard planning. These are the things, these are the experience factors that Hallmark asked the court to consider. He has the education, he has the pedigree, and he has been out in the real world dealing with issues like this for his entire career. Now, just because he doesn't have a specific expertise in hydrazine, the chemical, that is far too narrow of an application of the Hallmark standard. When we're talking about qualifications, the concept here is whether or not his real world expertise, his education, or some combination thereof can allow him to sufficiently educate the jury and provide the jury with that level of assistance at an expert level to move the case forward. And in this particular instance, based on the purpose of the testimony, which again is what Williams asked this court to consider, Scott Donnelly's purpose of the testimony is to say, 1, Dr. Najm's results are speculative. He's contradicting Najm. He's saying Dr. Najm's results are speculative, which, by the way, Dr. Najm finally admitted in his own deposition testimony. So I don't even know if that's at issue. I understand that plaintiffs raised that issue in the reply, but I think it's misguided given the black and white language of the Najm testimony that was supplied in the moving papers. But the fact remains that Dr. Scott Donnelly is saying Dr. Najm is missing a key element in showing that his pathways could create the amount of hydrazine that was detected in the FDA or Eurofins testing. So we went to Dr. Najm, we asked him the question, he said, you're right, I don't have that information, I can't do that. Dr. Scott Donnelly is saying, as a part of the root cause analysis, this is something you would want to know. And these other possible sources are things that should have been considered. Now, he admits a deposition, and I don't think there's any contest here, that he can't say to a reasonable degree of scientific plausibility that one of those alternatives was in fact the source of the hydrazine. But that's where we get back to Levitt. Levitt says you don't need that on the defense perspective. And so when it comes to Scott Donnelly, Your Honor, his qualifications meet the purpose of the testimony that he's providing. He's not a chemist. He's not saying he's a chemist, but he does have sufficient background in laboratory testing through Wyeth. He has a sufficient background in conducting HACCP plans, root cause analysis, and testing of products at a chemical level to determine whether or not certain contaminants exist. And under Hallmark, I think it's the 3rd part of the qualifications test, and I'm spiffing here, so forgive me if I'm off by one. But of the multiple factors that Hallmark asks parties to consider when it comes to qualification, that real world experience matters. And so that's the point we're making here.
So then, guess the next question, how, if at all, is this affected? Because plaintiffs did actually put this in this reply. You know, the partial summary judgment.
Your Honor, I've been asking myself that quite a bit since the last hearing. My belief is that the plaintiffs intend on bringing Dr. Najm in and putting him on the stand and furthering this erroneous argument that there's always been hydrazine in the water. And that's not what this court ruled And it's concerning, Your Honor, because if you read the reply to 9 and 10, I actually made a note because I think the court would like to address this. But in the replies, they state, and I'm quoting here, on December 3rd, 2025, this court granted plaintiff's motion for partial summary judgment as to liability against Real Water and Terrible Herbst based on issue preclusion. It's these overgeneralized, broad sweeping, inaccurate statements that are going to be presented to a jury. And so Dr. Scott Donnelly, the purpose under Williams that he's here for is to sit in front of a jury and say, hold on. Dr. Najm isn't opining that the level of hydrazine that came out of the FDA or the Eurofins testing has always been in that water. He can't. He's admitted as much. Dr. Najm didn't consider anything other than his own two pathways. He had access to the titanium tubes. He did nothing with them. Dr. Scott Donnelly is going to say these are other considerations that they should have considered when trying to do a proper root cause analysis. And so when it comes to Dr. Scott Donnelly specifically, Your Honor, again, it's the purpose that matters. If Dr. Najm isn't put up on the stand, then Scott Donnelly doesn't have to provide testimony about how Dr. Najm's wrong. But I can't speculate now as to what the trial strategy is going to be based upon this court's ruling. I mean, I can based on past trials, but I'm not going to speak for the plaintiff's counsel in this case.
Thank you very much.
And then,
Oh, sorry. Go ahead.
well, I was just going to say, Your Honor, I know I addressed, I want to afford plaintiff's counsel every opportunity, but I know I addressed Catherine Donnelly, motion to eliminate 10.
Well, let's talk about that one in a moment.
Yes, Your Honor, appreciate that.
All right, that was a lot. Let me try to break it down one by one. First, the court's inclination is correct that that both Donnellys are excluded or precluded from offering hydrazine formation opinions because they just simply lack the qualifications to do so. You don't even need to get past that point. And Your Honor, I think in your inclination, correctly honed in on the basic problem with these two experts is they're not hydrazine experts. Counsel's argument that you could be a microbiologist or go to school for microbiology or work in a lab that has nothing to do with hydrazine, and suddenly by osmosis you're an expert on every highly complex chemical reaction that exists that's just a false assumption. And you don't even need to look at the assumption. All you need to do is look at the deposition testimony and Dr. Donnelly's own testimony, where he repeatedly admits he knows nothing about hydrazine. Shane, if you have motion to eliminate number 9, we can start on page 5. He's asked about his experience and qualifications related to hydrazine. He says, I've never published anything on hydrazine. I've never dealt with anything regarding chemical water contamination. Everything I've done has been focused on page 5, Shane, has been focused on bacteria-related contamination in food safety. And he's asked specifically on this whole issue of, whether he, can transfer some expertise in food safety that he may have to the highly complex issues surrounding the formation of hydrazine in water. And he's admitted he didn't even look at hydrazine. He didn't do any research on hydrazine. He flat out says, is it fair to say that you did not necessarily apply any hydrazine articles or literature for purposes of your initial report? Answer, that would be fair. That would be fair. There's not a single piece of literature related to hydrazine in the slightest bit in his report that he relied on. And you know, there's all these arguments about Dr. Najim's testimony, and it's a misstatement of his testimony, and I'll get there later, but at the outset, what that issue pertains to, the expert issue, the scientific, technical issue that they're seeking to introduce this non-qualified expert testimony on, has to do with the formation of hydrazine in water and whether there's enough nitrogen to be available during the electrolysis process to cause the production of hydrazine in the water based on what Real Water was doing to manufacture the E2 concentrate. And Dr. Donnelly admits, he's asked, do you have any idea of how much nitrogen has to be available in the atmosphere for hydrazine to be created through this electrolysis process? Answer, I don't have any idea about what you just said at all. I don't have any idea how much nitrogen it would take. I don't have any idea about that. I have no opinions about that except it's scientifically implausible. Well, you can't just have someone come into trial who admits they have no idea what they're talking about and then have them give an opinion on what is plausible or implausible. It's a complete and utter lack of qualification to give this type of testimony. He's got no foundation, no specialized knowledge on the issue, and he's excluded without even getting into the other areas. And the same is true for Catherine Donnelly. Again, we're not seeking to exclude these experts on every single grounds that or opinion that they may offer in this motion. This motion is specific to hydrazine formation opinions, hydrazine causation opinions. And they've both very clearly said, we're not hydrazine experts. We don't understand how hydrazine is formed. We didn't research any hydrazine. We didn't do anything to formulate any ability to give a competent expert opinion.
So, if your motion is limited, as you're saying, and as it's, I would say, even titled in terms of, preclude Scott Donnelly from offering opinions on hydrazine formation based on lack of pertinent qualifications and or foundation. So you're not seeking to preclude either Donnelly in their entirety, right?
Not by this motion, correct, Your Honor.
Some other motions?
There is another motion about their failure to cite reliance materials.
Oh,
and
yeah,
I
think I'm inclined to deny those, but
no, I mean, if they have a relevant opinion regarding, food safety or HACCP procedures at Real Water, and those aren't before the court, before me, I can't speak generally, but I can say that this motion is limited to their opinions regarding hydrazine formation, causation, the production of it, the ability to come in and say, oh, Dr. Najim, his hydrazine opinions are wrong just because I say so, which is what they're essentially seeking to do with these witnesses.
Defendant's argument is at least in part that, one, there's a different standard in terms of, rebutting, addressing, in this case, plaintiff's causation opinions, which I think is accurate statement of the law. And then two, what they want to do is have either or both Donnelly's come in and say, Dr. Najim in his analysis missed this or that. That's kind of how I take what they're arguing. Didn't account for, root cause analysis, HACCP, whatever else. Would your motion preclude them from offering those opinions?
Well, yes, Your Honor, in terms of the hydrazine formation opinions, they want to present Scott Donnelly to come in and say, Dr. Najam's opinion regarding the formation of hydrazine in the electrolysis process is impossible. And he has no qualification, no foundation, no knowledge on that issue to be able to come in and rebut a well-qualified hydrazine expert or say what he missed, how it's impossible. He can't explain it. He says, I don't have any idea how much nitrogen it would take. I don't have any idea about that. I have no opinion about it. I can't explain why. I just say it's impossible. And how can he give that opinion in response to Dr. Najam? He is not a qualified hydrazine expert, and he admits he knows nothing about that topic. Dr. Catherine Donnelly, she doesn't necessarily squarely say Dr. Najam's wrong. She just says, well, you know, that hydrazine could have been introduced from these Superfund sites or through the municipal water. And those are opinions that are completely speculative for the reasons we laid out in the motion. And primarily because she did not do anything to determine whether it was even possible. And secondly, Dr. Najam actually did consider those. He was questioned about those exact issues and said, did you consider whether hydrazine could have been introduced through municipal water? And he said, yes, when I was doing my analysis, I considered that possibility and it wasn't possible because they filter the water that's coming in before they use it to make the electrolysis. So all of these issues have been squarely addressed and decided on in the prior cases. And now they're trying to come in and bring in these unqualified experts to try to rebut Dr. Najam. And again, there's a lot of reasons why that these experts should be precluded from offering these types of opinions. But the first one is that they don't have the necessary qualifications to offer scientific, technical, or specialized testimony regarding hydrazine and hydrazine formation in water. And that's what they're being offered to do. And that's what we're seeking to preclude on the limited basis. So that the first reason these two experts fail is they aren't qualified to give testimony on this particular subject. The second reason is that they don't have any adequate foundation to admit this testimony. Now, this goes to the Williams and Levitt case. Now, I think Your Honor recognized, and there is a kernel of truth, that there are two different standards. You know, if you're introducing an independent alternative causation theory, it has to be to a reasonable degree of probability. It has to meet that standard. If you're using the expert testimony to contradict or rebut an expert, then it may not have to be, every possible cause may not have to be stated to a reasonable degree of probability, but it's still subject to threshold admissibility requirements. Namely, it has to be not based on speculation and supported by competent evidence and research. And what we have here, if we look at Dr. Donnelly's opinions or testimony on page 8 of the motion, Shane. He's very candid that he admits that he does not know where the hydrazine came from. And that, if we look at page 7 as well, Shane, he's asked, okay, you saw that the FDA found hydrazine in every sample of the E2 concentrate in which it was tested. How did that hydrazine get in there? Well, I don't know. That's speculation. I'm totally speculating. I have no idea. I'm not a hydrazine expert. I can't tell you how it got in there. But he wants to introduce these alternative, well, it could have been this, it could have been that, it could have been this. There's no foundation for that type of opinion. And to suggest that that's what Williams or Levitt allows is simply not true. If you look at the Williams case and the Supreme Court, you know, that's a very well-reasoned opinion, and it's well explained. And they're talking about when is it not when does it not have to be stated to a reasonable degree of probability standard? And the first thing they said is, well, first of all, you have to take into account the plaintiff's theory for it to not be subject to the reasonable degree of probability standard. If you don't, then you're just introducing the fact of causation on your own, and you have to state it to a reasonable degree of probability. It has to be more probable than not. And in this case with Dr. Najm, they're not accepting his theory as possible. They're saying it's impossible. It's not possible. So by doing that, they're subject to the reasonable degree of probability standard. They're trying to introduce the fact of causation, where the hydrazine came from. You can't just say they're wrong and it could have been, could have been, could have been. I mean, that's not what Williams says. And they give the example. They say, look, if you have 4 plausible causes for this, in that case, it was hepatitis, and one expert, and you know, you get 100 experts, and 1 out of 100 says, it's my opinion to a reasonable degree of medical probability that it was cause A. And then you get 99 experts who say, well, you can't say it's cause A with certainty because it could be B, C, or D. They're not precluded from saying, well, it could be it could be B, it could be C, it could be D. And if those causes are supported by, aren't speculative, and they're supported by competent evidence and research. But that's not what they're doing here. They're not saying, oh yeah, it could be in the electrolysis process, but it could also very likely be from 1 or 2. So you can't say Dr. Najm can't say to a reasonable degree of probability that his causation theory is right. They're not rebutting him. They're just dismissing it and saying it could have been, could have been, could have been this, it could have been that, when there's no evidence to support any of it. And it's pure speculation that they admit is pure speculation. There's no evidence to suggest that there was a Superfund site near the Desert Inn plant.
Let's stick with, let's stick with Dr. Scott right now.
Scott Donnelly?
Because the Superfund site's her, right?
Right. So with Dr. Scott Donnelly, he's clear as day. He says, I don't know where the hydrazine came from. He's totally speculating. Williams and Levitt do not say, oh, you could just come in and say, well, it could have been this, it could have been that, it could have been this, could have been that. In fact, they say the exact opposite. They're very specific to say you cannot speculate on causes that are not supported by evidence or research. And they haven't showed you any evidence or research that supports any alternative cause of the hydrazine except for Dr. Najm's previously unrebutted opinion that it was formed in the electrolysis process. That gets me to the third point. This issue was decided by the court's summary judgment based on issue preclusion. The court's order was based on Judge Kishner's order applying that applies to both real water and Terrible Herbst. And Judge Kishner's order dealt with all these same issues. It was the same Dr. Najm report and opinions that were in front of her. It was the same arguments of lack of evidence of any other explanation, no expert to be able to rebut that Dr. Najm's theory was true and correct. No other explanation for why hydrazine was found in every sample of the E2 concentrate. No evidence to rebut that the concentrate wasn't always made the same way, using the same titanium tubes and the same general formula and process. All of these issues were argued in that summary judgment motion, and they were decided against these defendants, and they were granted issue preclusion here that all the water that was at issue with these plaintiffs was defective and unreasonably dangerous for having hydrazine, and whether Mr. Herbst consumed it or whether it was a specific cause is a separate issue, but this is defect. This is liability. These are the elements. These are the same exact things that were decided in summary judgment by Judge Kishner and applied issue preclusion here. And Your Honor, I think it is important to note that that order and the evidence that existed when that order was decided and Dr. Najm's opinions here, they were really uncontested and not in a vacuum. Real Water initially in the Gallagher trial, in the first trial, they retained a hydrazine expert. They retained a chemist. Her name was Dr. Susan Richardson, and she was a qualified chemist. And this was before we disclosed Dr. Najm. And at the initial expert disclosure deadline, plaintiffs disclosed their expert reports, and Real Water and simultaneously disclosed its experts reports. And Dr. Richardson, their hydrazine expert, her opinions were based on Dr. Najm's published literature regarding the formation of hydrazine in water as a byproduct of the water filtration process. And Shane, if we could pull the reply up, the joint reply on page 6. Dr. Richardson's asked about her research and studying hydrazine, and she said, yes, I did literature review. I actually did what the Donnellys didn't do, and I went out and studied this chemical to formulate my opinions in this case. And I found Dr. Najm's reports, and she cited them as her reliance materials, and her opinions were basically based off Dr. Najm's published research without knowing he was our expert, and recognized he was a preeminent expert in the field. She stated she relied on his work, that he's authoritative and well-respected in the field of hydrazine formation in water. She reviewed his expert report that was simultaneously disclosed, and she said, you know, it's the same report that was produced in this case about the formation of hydrazine in the electrolysis. And she said, yes, I looked at it. I don't disagree with him. I mean, the chemistry makes sense. This is their chemist expert who simultaneously disclosed her expert report and agreed with Dr. Najm. And so when they go in the Gallagher trial, and we cite all the times where they repeatedly say, we don't need a hydrazine expert. We agree with Dr. Najm. You'll hear from the experts. Hydrazine was formed in the electrolysis process. We don't dispute what Dr. Najm's going to say. We agree with Dr. Najm. It's very likely that all the water had hydrazine in it because the concentrate has the hydrazine in it. All of those statements were based on the fact that they went out and got qualified experts who agreed with Dr. Najm. And
So you've got 3 more minutes total.
I'm
You know,
wrapping up right now, Your Honor. And so those admissions weren't done in a vacuum. They were done based on the evidence that has been established, including in Judge Kishner's summary judgment order, which is issue preclusion here. So this issue should be decided on that basis as well.
Thank you very much. So as to plaintiff's motion eliminating number 9, preclude Real water expert Scott Donnelly from offering opinions on hydrazine formation based on lack of pertinent qualifications and or foundation, and now to also include, as was appropriately brought up in the reply, given what happened after the final motion with the gray of the partial summary judgment, court sticks, well, to be clear, court grants plaintiff's motion limiting number 9. Based on Dr. Scott Donnelly's lack of qualifications and or the partial summary judgment issue preclusion and or the lack of competent evidence to support his opinions on the hydrazine formation. So that one was granted. Defendants still have 20 minutes. This next would be Catherine Donnelly.
And Your Honor, I don't know if Councilor Pepperman wants to go first, but I can address the content issue in about 30 seconds.
Okay.
So my motions-
No, I'll.
He should save for rebuttal I would. Cause he's got like, 2 minutes.
So Your Honor, just 2 points briefly on Catherine Donnelly. First, as it comes to content, I would direct the court back to Levitt. In Levitt, the notion that you have to adopt some semblance of the plaintiff's argument in order or opinion in order to bypass the scientific plausibility standard is just flat out wrong. Levitt was about a LASIK surgery. The alternative theory had to do with an abuse of eye drops. There was also a question about whether or not the blurry vision in that case had pre-existed the surgery and was just an exacerbation there too. And point being, Levitt said you don't, the doctor in question, and I quoted you, I wasn't interpreting the lie, literally quoted the case, said that the eye drop theory was the one that was completely independent of the LASIK, and it was still okay, even though there was some speculative opinion involved. So to the extent, just to clarify the record, plaintiff's position on, or their interpretation of Williams and Levitt isn't just too narrow, it's wrong. So with that in mind, as it goes to Catherine Donnelly, page 6 of the opposition provides the context on the Superfund site. And I fully understand, Your Honor, having, without divulging any privileged communications, how the Superfund site issue in a vacuum could be questioned, right? So I did ask Dr. Donnelly to provide a little bit of color or context as to why. And what you can see here is that Dr. Donnelly is what she's discussing here is the lack of a proper root cause analysis from the FDA that goes into page 7. Says as no root cause analysis was conducted and the probability of environmental contamination as a cause of hydrazine contamination cannot be ruled out. The very scenario that led to acute non-viral hepatitis could happen again without these plans in place. The point here isn't saying what caused hydrazine. The point is, well, one, it's talking about whether or not appropriate HACCP procedures implemented by Real Water could have prevented the injury, right? There are other factors in play here besides causation. It's what could Real Water have done here? What was their intent? What was their knowledge base? Are punitive damages appropriate? There are all of these other collateral factors. And so the purpose of her testimony was never intended to be a causation opinion. And I think we put that very clearly in opposition. What she's doing is saying from the lens of a HACCP professional, right? Which is what plaintiff's expert Catherine Hutt is going to testify to. That's why our Catherine is here. And she's saying, no, look, these are the issues that I see that inform these other aspects of the case. And so with that, Your Honor, if you have any questions about Superfund side or municipal water, or anything else. I don't want to belabor the point, but it is clearly set out in the opposition. And again, if we're following Williams' purpose-driven standard and we're following Levitt on, you know, analyzing what the actual content of the testimony is, I don't think there's any question that Catherine Donnelly is a HACCP expert and is more than duly qualified to opine on things that she's been doing her entire career. And so if she wants to talk about root cause analysis and hazard analysis and applicable precautions and statutory compliance or regulatory compliance, I think that's well within the purview of the issues in this case. So with that, I'd answer any questions you have.
No questions.
Thank you.
Thank you. 2 minutes.
Your Honor, this idea that Levitt or Williams says you can just speculate as to alternative causes is just, it's not serious. Levitt, the eye drops, that was the expert testified to as the alternative cause. He said there was evidence and research that supported that abuse of these prescription eye drops could cause the injury that she suffered. He wasn't just speculating like, oh, it could have been eye drops. It was supported by evidence in the case and research. And the speculation that's referred to by the Supreme Court in that case was, he said, if she had followed my continued directions, she could have avoided the injury. And that was the speculation that the Supreme Court was saying, well, yeah, maybe that portion's a little speculative, but the court wasn't saying the alternative causation theory was speculative. That was supported by evidence and research. And simply put, if you've seen evidence that would support hydrazine could come from some Superfund site in Henderson, when the concentrate was never made in Henderson, was only ever made at Desert Inn, or it could come from municipal water based on the real water system. I'm not aware of that evidence. They have not shown it. There is no evidence or basis to support their speculation that, oh, maybe hydrazine came from here or there, or could have came from here. I mean, maybe space aliens came and zapped it in. It's the same type of situation, Your Honor. And so for those reasons and all the reasons before, we ask that Catherine be precluded from giving these opinions as well.
I understand probably better than I have before why at trial I let attorneys know that we need to end every day at about 5 o'clock.
I'm trying.
No, that's, you're back in front of me on Wednesday. Is that right?
That's correct, John.
This Wednesday in the morning, I think. Yeah, I probably told you, but we have a bench trial set to start tomorrow. May or may not go, but I'll plan on giving you my ruling on Wednesday. I heard somebody whisper what time. That's a good question. Bear with me a second.
Last time we were before you, Your Honor, you instructed us kind of 10. I don't know if that still stands, but that's what we currently have.
The good news is I'm at half my Wednesday calendars going away. Is Cool Bali really on?
It is. All the motions that it says it has are based on calendaring for the clerks, so there's really one big.
Yeah, come in at 10.
Can we ask for a reprieve on something?
Sure.
It came to our attention it came to my attention once I got here today. I had a motion been filed for Pro Hoc for Terrible. And the court's gonna hear it on Wednesday, Your Honor.
There's
we need-
two, I think, didn't it?
We need time to file an opposition. There's gonna be a significant opposition to that request. If it was something we thought would be, perfunctory. And we haven't done this before. We haven't asked for more time like that before, Your Honor, on one of these. But there's some issues that really need to be briefed, that we'd like the court's attention. And I would ask that you give us to maybe noon on Friday to get it out. I think we have to get a transcript and some documents we want to add to our opposition to this. But we really could use additional time, and obviously you know what we're working on right now.
Could I be heard, Your Honor?
Sure.
So there's two different attorneys. Are you asking for more time for one of the particular ones?
Well, we need more time, certainly for the one I just found out today. I found out about one, the other one. Yeah, first time, Your Honor. So yes, we need time for both of those, Your Honor.
Both of them?
Yes.
Well, I signed two today, one earlier than the other one, obviously. Are they defendants planning to have them argue any of the motions? Would be the first question, I guess.
Not for Wednesday, Your Honor, but we are 15 days from trial. Anyway, as soon as possible, if you could.
That's why I asked, close at by noon on Friday, Your Honor. We're here today. We're gonna be working all day tomorrow. We'll be here all day Wednesday. That gives us just a day and a half really to focus on the oppositions. There is some issues I think the court will take interest in.
So any issue with doing that on Monday?
Having the hearing on Monday, Your Honor?
And that's more of a question for the defense.
I'm sorry, I didn't hear.
Any issue with, so I set them on Wednesday, I think, in chambers on Wednesday. Boy, oh boy. Monday, especially if there's gonna be a substantive opposition or oppositions, maybe we do them Monday in court, but I don't know if there's scheduling issues on your side.
Or is the court anticipating an opposition by defendants to this?
Claims.
So
So you were talking about your opposition by Friday at noon.
Yes.
Is there a further briefing allowed or?
oh, of course, you could get a reply. But
We were on an OST, we're 15 days from trial. So whatever the court's inclined to do, I just want.
yeah, well, so the scheduling's, so I'm thinking out loud, but the scheduling crunch begins with, I don't know when the OSTs were submitted, but fairly recently, last week.
So both are being opposed by Friday at noon.
Yes.
Can we do them on Monday at our special session on Monday?
That's a question for defense.
We'll do that, Your Honor.
Okay,
Thank you, Your Honor.
thank you.
Particular time we're before you on Monday, I forget.
1:30.
Okay.
I don't have trial though. Okay. That it for today? I don't think we got through them all, did we? Okay, we've got. Yeah, on Wednesday, we'll start with the ones we didn't get to today and see how that goes.
Sounds great, Your Honor. Thank you so much.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.